Hi, I'm Kyla, and I'm here to answer some questions you have about your driving tickets. It is not necessary to testify at a traffic ticket trial. Sometimes, however, it may be critical that you do so. The reason for this is that some defenses to traffic tickets are affirmative defenses. A good example of this is a distracted driving ticket. There's a defense in the Motor Vehicle Act that you are permitted to use an electronic device for the purposes of making an emergency call. However, police officers are not going to know whether or not you're using your phone for the purposes of calling 911, unless you tell them at the roadside, which you shouldn't do. And so it might be necessary to testify to explain that you were on the phone with emergency service personnel at the time. You may also wish to testify in circumstances where the officer is alleging you were going a much higher speed than you were going. But be very careful, because if you testify in your traffic ticket trial, there are certain things that you may have to establish in order to prove your defense, or that you may have to establish in order to undermine the police evidence. Knowing what those factors are requires a good understanding of the law and the essential elements of each offense in the Motor Vehicle Act, which is why it's important to have the assistance of a lawyer. Additionally, if you take the stand and testify in your traffic ticket case, you are then subject to cross-examination by the police officer. Knowing the scope of the permissible questions in cross-examination and how an officer is permitted to conduct cross-examination can also shield you against having your evidence undermined by an officer who's conducting a cross-examination against you when you don't have that knowledge.